next topic I am going to present is about mistake. Mistake may operate upon a contract in two ways. It may defeat the consent altogether that the parties are supposed to have given, that is to say, the consent is unreal. Two or more persons are said to consent when they agreed upon the same thing in the same sense. So definition of a mistake comes to as mistake happens when one of the parties has some misconceptions about the fact stated in the contract. Section 20 defines illustration two persons contract that one of them will buy their house but none of them is aware that the house was burned when they were negotiating the contract. The agreement is void. Section 20 will come into play when both the parties to an agreement are mistaken. Their mistake is as a matter of fact, and the fact about which they are mistaken is essential to the agreement. Contract caused by mistake of one party as to the matter of fact. A contract will not become voidable when one of the parties is under a mistake relating to some fact involved. Certain facts are essential to every agreement. They are the identity of the parties, the identity and nature of the subject matter of the contract, and the nature and content of the promise itself. And mistake, we can say that mistakes as identity. Mistake as to identity occurs when one of the parties represents himself to be some person other than he really is. We can state that particular case here, Jagannathan and Sissy of State for India. A person called S, a brother of the plaintiff, represented himself as plaintiff and thereby induced a government agent to contract with him. The court found that government agent was deceived by the conduct of the plaintiff and his brother as to the person with whom he was dealing held that there was no valid contract. The defendant's agent intended to conceal only with S brother and not with S, and S knew this was the consent was prevented. It means that an offer without the consent for one person cannot be accepted by other. So here the contractual relationship between various parties are framed, validated and governed under the Indian Contract Act. And in the contract, both parties must give their consent voluntarily and it must be genuine also. The principle of consensus ad idem is followed, which means that the parties entering into the contract must mean the same thing in the same sense. If the consent of the parties to a contract is given under a mistake, then this will arise the question pertaining to the validity of the contract. In a layman language, the term mistake refers to an incorrect belief that is innocent in nature, which led to one party to misunderstand the other. The term mistake is not defined in the said act. However, the concept related to mistake is dealt under section 20, 21 and 22 of this act. There may be two kinds of mistakes, mistake of law and mistake of fact. The exact demarcation between legal error and factual error is often blurred and hard to determine. Here, the mistake of law means any contract which is performed by the parties in ignorance of the law, which is essential for the performance of that contract. Section 21 of the said Act deals with the effect of mistake as to law, and it states that a contract is not voidable because it was caused by mistake as to any law in force in India. But a mistake as to law not in force in India has the same effect as mistake of fact itself. Then mistake as to nature of promise. So here this principle is well established by authorities that when a deed of one character is executed under the mistaken impression that it is of a different character, then it is wholly void and inoperative. Thus, where a gift deed is signed under the impression that it is only a power of attorney, the deed is inoperative. Therefore, no party shall be allowed to claim any relief on the grounds of ignorance as ignorance of Indian law. This will also include a wrong interpretation of any legal provisions. For example, as per the provision of Indian law, A has to recover the amount of loan within 3 months from the due date. After that time, barred debt is imposed. Now, if A does not show any interest in the recovery of loan amount, during these 3 months because of not knowing the law, mistake of law, then A cannot take it as an excuse of defense. This is about mistake of identity and mistake as to the nature of promise. Thank you.